All right, everybody. It's shearing time.
First, I'm first. Shear me. I'm ready to be sheared.
Look, I don't want to do this.
No. It's cool, man. It's cool. It's all good.
Well, you're not going to do that thing.
I'm not going to do that thing. It's fine. It's fine.
All right.
Cool. Oh, yeah. Yeah, that's good. Yeah, shear it. Fucking shear me. Shear that goddamn shit off me. Fuck yeah.
I thought you said you weren't going to be doing
I am.
that
I'm doing a bit. I'm just doing a bit. That's all. It's all good. All right? Okay, just go. Do it.
All right.
Do it.
All right.
Oh, yeah. Fuck. Fucking shear my ass, bitch. Yeah, make me naked. Make me a naked fucking skin sheep. Yeah, run that thing all over my ass. Yeah, fuck yeah!
Okay, I'm not doing this.
And that apparently was a commission from Stingy. You know what? I hope you paid through the nose for that, because that's, yeah, no. But let's get stuck into it, people. Welcome to today's episode of Law News and Laughter. Okay, let me just readjust here, because first things first, thank fuck I'm even here, because apparently, like, 180 seconds, yes, I'm being that specific, 180 seconds before I was ready to go live, I clicked on that video, and I couldn't hear a goddamn thing. Because, of course, I restarted my computer, and for some reason the computer decided in its infinite wisdom to disconnect from the Rodecaster. So it had everything else, but I couldn't hear a goddamn thing. Boost says he sent a DM to share. Fair enough, I shall have a look in a minute. So, the reason we're here tonight, well, today, this morning, whatever you want to call it, is to stroke my ego. We know that. But the main story that we're going to talk about tonight is a 7-year-old from Texas who really shocked his principal when he just casually mentions that he yeeted somebody in Minecraft. Going to look a little bit more further into the details, but then we've got all sorts of the sheep emojis. Got all sorts of random crap to look at, but I think it should be all right. Now, where was that? Boosh said he sent me something that he wanted me to look at, just very quickly. We'll have a look. What's this? Send a link. What's the link? Like you and Stingy are on the same wavelength. Alright, hang on. Let me just quickly switch this across to... Oh, hang on. You know what? No, I'll just drop and drag. We can just drop and drag. God, I love Family Guy. Oh, God, yes! Oh, you're kidding me. There was no audio on that? Of course not. Why on earth would there ever be audio? Because I forget to hit the button. And there still was no audio. Oh my God.
Finally, I'm one of those guys who can't wait to get to work in the morning. Like a dairy cow.
Oh! Oh! Oh, yes! Yes! Oh!
It's the ooh that gets me every time. All right. What was that? The other thing that someone mentioned was what Biden did to Title IX. Do I even want to know? Do I want to know what he who should not be named did this time around? I mean, I don't know. I feel like if I spend too much time bagging out Biden, that I'm going to get called a MAGA rat again. God, that was funny. I feel so much like I should reply to that particular comment that was left on the video and just say, dude, thank you so much for the comment. It made some excellent content because I spent a good 20 minutes bagging you out across various streams. What was that? Stingy dropping a $5 super chat already. Thank you very much for that, pal. Sheep thing was from Seth, Cavalcade of Cartoon Comedy. Sent you the entire clip, but here's $5. No worries. Okay. All right. So let's have a look at this news story, shall we? Texas 7-year-old shot and killed a stranger sleeping in an RV after grabbing a gun from a glove box in his grandpa's truck. The child allegedly admits years later. Grandpa, you got some splaining to do. A now 10-year-old child in Texas faces a charge of threatening to kill a fellow student during a school bus altercation separately admitted to school officials after the incident that he fatally shot a sleeping stranger years ago at an RV park in Nixon just 1 week before he turned 8, authorities allege. God bless Grandpa. According to the Gonzales County
The sheep thing was from Seth, Cavalcade of Cartoon Comedy. I sent you the entire clip. But here's $5.
Then is the grandfather going to be charged with the murder because it was his weapon? That's a damn good question, hey Joe. See, okay. I mean, I can understand why people would be on edge given what happened with the Crumbly case, given now that there's precedent for various things. I want to get through this article because I'd like to make an informed opinion based on it, but if the weapon wasn't properly stored and it can be proven that the kid actually killed somebody, because you got to remember, this is someone that was almost 8 years old, so we're talking 2 and a bit years ago. Is the kid making it up? In Michigan, yes, because it's effing... Damn, I have too many sound effects now.
Retard.
There you go. It's called the Gramps Corpse Loophole. According to the Gonzales County Sheriff's Office, the shocking development in the unsolved January 22 murder of a 32-year-old Brandon O'Quinn Raspberry began with an April 11 school bus dispute between the 10-year-old boy and another student at Nixon Smiley Consolidated Independent School. The Sheriff's Office said that school officials contacted authorities the next day, but not just about the alleged threat to kill. This kid's starting to sound more and more like a psychopath. When the deputies arrived, he spoke with school officials who informed the deputy the child made a statement that he shot and killed a man 2 years ago. It's a 10-year-old. He could just as easily be lying. The Sheriff's Office said on Thursday before pointing out that they cannot bring murder charges in this case under the Texas law because a child does not have criminal culpability until they reach the age of 10 years old. Yeah, well, age of innocence. Duh. It's a little bit concerning that he was proud of it, though. So, shorthand, they added gender identity to Title IX. Think about that. Oh, fuck. A 12-year-old kid in Florida was charged as an adult for shooting his friend in the garage accidentally. He invited the friend over, found the gun, loaded it, and then shot another kid. Jesus. The juvenile faces a terroristic threat charge related to the bus incident, however. Authorities said that the student under questioning by school officials alleged that about the alleged bus threat began to describe Raspberry's death at the Lazy J RV park, which took place just 4 days after the victim moved there. Investigators found that Raspberry had been shot once in the head, but they uncovered no clues about who could have killed him by checking cell phone data. What? Hey, Aussie Tank, can't complain. Why did the school wait until the next day? It may well just have been that it wasn't raised with the school until the next day. I mean, if it was on the bus home, you know. Title IX is dead. You can only hope. Wait, what's that? I missed something there. Because I'm on Top Chat. Don't be a moron like me and be on Top Chat. Be on live chat, people. The future is Gramp loops. That's all the Zumba talks about. Ugh. Found that he'd been shot once in the head, but they uncovered no clues. That's because authorities now say the person who killed him was a complete stranger to him. Investigators determined, based on the information the child told the school, that the child may have knowledge about the murder of Brandon. The child was transported to a child advocacy center where a forensic interview was conducted. During the interview, the 10-year-old child described in detail that 2 years ago he shot and killed a man in a trailer in Nixon, Texas, the sheriff's office said, emphasizing that the juvenile had confirmed details that only the killer would know. Okay. Alternate theory. Because you know, man, gotta play devil's advocate. Grandpa shoots a random person, tells the kid to take the fall because he can't be charged. Hey there, sonny boy. How much you love your gramps? You gonna take the fall for me? The child allegedly confessed that he was visiting his grandpa's place at the Lazy J RV park on January 16, 2022, when he decided to grab a gun from the glove box of a relative's truck, went to the Raspberry's RV, and shot the victim in the head as he slept, then put the firearm back in the truck as if nothing had happened. Tagged you in the New South Wales stabbing issue. The chief said we make information, not you, and threatened punishment for people who produce information not in alignment with the state. Oh yeah, don't worry. We're going to get into the whole e-safety commissioner bullshit. I may be moving out of Australia sooner rather than later. I'm not happy. I think this might have been an accident, not a calculated thing. That's what I'm saying. This, for an 8-year-old to do that, seems a little bit like... I could understand the grandfather doing it, but an 8-year-old walking in and just, like, blowing someone away that they know nothing about, they've had no interactions with, sounds a little bit far-fetched to me. The suspected shooter allegedly admitted to that the extent that he knew Raspberry was as a total stranger he happened to see outside that day. Nor did the victim do anything whatsoever to make the suspect mad, investigators said. When asked, the child stated that he had never met Brandon and he did not know who he was, although he'd observed him walking around the RV earlier that day. The child was also asked if he was mad at Brandon for some reason, or if Brandon had ever done anything to him to make him mad, to which he stated no. So the kid's either a complete psychopath or he's covering for the family member. Sounds so plausible for an 8-year-old? Not exactly. 8-year-olds can be vindictive. Well, I don't know that vindictiveness would come into this. Because the simple fact of the matter is, if he's that nuts and insane, it can get worse. For example, what a cop did to the 13-month infant girl. Yes, I chose not to cover that story, Jason. Thank you for sending it to me, but there are certain things that even I can't. If that one makes it to trial, I may go in depth to it, but at this instance, what a grown man did to a 13-month-old child behind a closed, locked bathroom door is not something that I really wanted to talk about today. But I appreciate you sending it through. Problem child is the bow tie killer. Bet he's a Fortnite psycho kid. Could be. The sheriff's office said that they tracked down the gun at a pawn shop the day after the child informed investigators during the interview that the gun had been pawned by his grandfather. Yeah, no. This stinks to high hell. Because all of a sudden you've got, oh, this weapon was used to kill somebody. Grandpa's just pawned it. Yeah, I'm gonna say no. And the guy stabbing the 9-month-old. Well, yeah. Thereafter, the 10-year-old was evaluated at San Antonio Area Psychiatric Hospital before he was subjected to juvenile detention in the bus threat case, authorities said. Brandon Roseberry's obituary listed his date of death as January 19, 2022, which is the day after police said that he was found dead. Authorities detailed that the Lazy J RV park owner was the one who found Raspberry dead on January 18, after the victim's employer worried that it had been 2 days since he last showed up to work. Raspberry's longtime girlfriend, Brandy Kamer? She's a Kamer. Spoke with the Gonzalez Inquiry about her shock that someone so thoughtful, intelligent, hard-working was shot dead for no apparent reason. We hope they find who did this and justice is served, she reportedly said. The sheriff's office now claims to know who killed him, but justice is another story. 8-year-old serial killer is extremely rare. I would think so. And this seems a little bit less, like... It doesn't seem plausible to me. 8-year-old randomly walks into grandpa's car, takes a gun, shoots somebody in the head. More to the point, how the hell did he get into the RV by himself anyway? Shoots someone who is asleep in the head. Nobody hears the gunshot. The kid calmly walks back, puts the gun back in grandpa's glove box, goes inside. Nothing's ever heard about it except for the fact that grandpa then almost immediately goes and pawns the gun. I think I call bullshit. I really do. Something stinks for sure. Yeah. Gramps often pawned it and the child is cover for Gramps. That's legitimately what I'm thinking. Sent you an NPR article on the Title IX stuff if you're going to cover it. Okay. Well, we'll have a quick look at that. Bloody hell. What are they doing with this? Biden administration adds Title IX protections for LGBTQ students and assault victims. Biden administration released rules on Friday that protect the rights of LGBTQ students and change the way that schools respond to allegations of SA and misconduct. It's a long-awaited answer to campaign promises made by Biden to reverse Trump-era regulations. He said was silencing survivors. The Education Department's updates to Title IX. The 1972 law prohibiting sex discrimination in federally funded school programs are expected to go into effect on August 1st. Under the new rules, in-person court-like proceedings for allegations of SA, including cross-examination of alleged victims, are no longer required. I'm sorry, what now? I'm sorry, what? What happened to the right to face your accuser? What happened to the right to ask questions? At what point what? Someone could just make a random allegation and you can't question them about it? What do you mean it doesn't seem plausible? Oh no, I'm not saying that it doesn't. I'm not saying that. At this point, on the balance of probabilities, that 50.1%, I think it's more likely the grandfather was involved. Personally. Yep, you read that right. Way to fight back, pull your kids out of sports in schools. I think this is less about whether or not they're just in sports, though. This seems like it would be across the board. That rolls back Trump administration protections for accused students that victims advocates say re-traumatize survivors and discourage reporting. Schools will now have the flexibility to question witnesses in live hearings or in separate meetings. If a school chooses to hold a live hearing, alleged victims have the right to attend remotely. Okay, maybe I need to actually read the bill then, because I've got to take into account the potential bias of the news agency. Schools have the flexibility to question witnesses. So it's an inquisitorial process as opposed to adversarial. You don't have the right. You've got to trust that the school is going to ask the questions. Don't know that I like that. Can't drink all day if you don't start early in the morning. Let's go. You missed Lady Overlawd's stream. Okay? Don't you start trying to fill me full of liquor now. I got to get up early in the morning and take the family to the on a road trip. So way worse time for mass homeschooling. Yeah. The Biden administration also broadened the definition of what counts as sexual harassment, so more cases might qualify as serious enough to require a school... Am I even subbed to a channel? No, it was here on this channel. And I gave you like a week's notice. Men can now demand to be housed in women's dorms rooms. From what I've heard, use these showers. It's horrifying. That reverses Trump-era regulations that had narrowed harassment to what is objectively offensive. Got to watch NBA at 5:30 apparently. Well, as in, like, because the time zone changes, you got to wake up to watch it, or you're taking family members to it. Practicing till like 3 a.m. Then need a few seasons. No, fair. Look, dude, fair enough. I'm just saying I can't drink tonight. As much as I would love to. It was a takeover stream a couple of weeks ago. Yeah, found the PDF government doc file. Oh, that's all right. I think I've got it here. It was linked in the article, so that's fine. I'll have a look at it in a second. Narrowed harassment to what is objectively offensive. A nation's educational institution should be a place where we not only accept differences but celebrate them. Not all differences should be celebrated. Let's Okay, let's be perfectly honest. Son's making me watch it live. I feel sorry for you, Cakes Boo, but you know it's a you're not going to get to do it very often in life, so enjoy it. That's what I have to tell myself anyway. Hey, Carlos, 24/7. Hello. Crap. I had a thought on this. Nation's educational institutions should be places where not only accept differences, but celebrate them. Well, I mean, look what's happening in that school where you've literally got the furries that are allegedly biting and scratching kids. Is that really something that needs to be celebrated? Especially when you've got another furry, like a more senior furry, saying that this is bullshit and that shouldn't be happening. Like, if they've got their own calling them out, you know shit's going sideways. And the fact that the Divide and Conquer is the government's favorite game to play historically, yes. And there's just way too much. Sorry, I looked over and Stingy's message with the Title IX document. Twitter blocked it, or should I say X blocked it, saying it was a suspicious link. Sorry, that was just funny. Senior furry. I know, right? That was entertaining to me too. A nation's educational institutions should be places where not only we accept differences but celebrate them. Places that root out hate and promote inclusion, not just because it's the right thing to do, but because our systems and institutions are richer for it. Show me where the systems are richer for our children having to be in the same area as someone taking a shit in a litter box. Show me where the enrichment is. Unless one of those kids is dropping enriched uranium in the litter box, I see no enrichment. Did you see I sent you the photos of the kids wearing the furry heads in school? Yeah. No, I saw. Protected class, they can do whatever they want. Good God. See, here's the thing. Come November, do I think anything's going to happen in the election? I don't know. There's already been, like, with what was going on with the allegations that the Chinese are already attacking the infrastructure and they're laying down the line to say that the election's been interfered with potentially or whatever else. YouTube, I'm just speaking hypothetically here. I don't know that anything's going to come of it. I mean, if there had been a certain other individual in power for the last 4 years, it might have made a difference. You reckon Biden's going to win by a landslide? It's a terrifying thought. But the trouble is that we're due for elections in May next year. And Albanese seems to be trying to push through some shit too. But I don't see anything changing. Even if Dutton the leader of our Conservative Party, gets in. What government is going to give up power? It's never going to happen. Taxes were supposed to be temporary. What are we? Almost 100 years later? 80 years later? And we're still putting up with this shit? Yeah, no. Perhaps most contentious, the new rules also officially broaden the interpretation of Title IX to cover pregnant, gay, and transgender students. Title IX requires more, and these final regulations provide it, said Catherine Larman, Educational Department Assistant Secretary for Civil Rights, who also served in the same position in the Obama administration. Under the new interpretation, it could be a violation of Title IX if schools, for example, refuse to use the pronouns that correspond with a student's gender identity. I don't want to live on this planet anymore. Republican Representative Virginia Fox, chairwoman of the House Committee on Education and Workforce, blasted the updated regulation, saying it dumps kerosene on the already raging fire that is the Democrats' contemptuous cultural war that aims to radically redefine sex and gender. The Biden administration's changes avoid the controversial question of whether schools can ban transgender athletes from competing on women's and girls' teams. Officials have proposed a separate rule on that issue, which they say is still in the works but offered no timeline. Of course not, because as long as it's still in the pipeworks, they can still potentially try and get votes from individuals that won't get pissed off by it. Power of the people must be taken back because it won't be given. Of course not. Government can and will give up the power at the end of a pew pew, and it's coming. Jason, I don't know that it is. That's the problem. Over the last 12 months, looking at the news, talking with you guys, like doing my own research and all sorts of shit, I'm starting to think that the majority of the population's too busy stuck in the rat race and they're all apathetic about everything. I don't know that anything's going to change. Ever. Yep, Obama, this excludes Christians, conservatives, Republicans, Catholics, straight people, and white people. It's repeal of equality. After years of pressure from students and survivors of SA, the Biden administration's Title IX update will make schools safer and more accessible for young people, many of whom experienced irreparable harm while they fought for protection and support, said a senior manager at the advocacy group Know Your Nine in a statement to NPR. But critics say that the changes violate due process rights for accused students. Goal is to keep people too worn out to affect change? Yeah. The Department of Education should recognise that removing procedural protections for students is the exact opposite of fairness, said Will Creeley, legal director of FIRE, the Foundation for Individual Rights and Expression, on social media. And by expanding the definition of sexual harassment, the new regulations threaten expressive rights. Wrong, 80% of the country hates Biden. The Biden media says it's only 45%. Well, we'd never know. We would never know, because if they actually legitimately thought that, oh, we'll hold a poll or something, no one's going to trust the results of anything. So, all right, where is this piece of BS? Holy fuck, it's 1,400 pages. Go out, go to bars, go to restaurants, talk to people. The only people who like Biden are already set for life. I'm not shocked by that. Knew this was coming after the Aussie law changes? Yep. Guys, how many times do I have to say it? Australia is the petri dish. Albanese has his head so far up Biden's ass, not to mention what's going on in the UK, and, wow, I just realised that I've not been keeping track of the fuck counter either. Simple fact of the matter is, we're the petri dish. And I noticed that with everything that's been going on with, like, the e-safety commissioner and that sort of thing, and Musk and free speech and all that sort of stuff, I noticed that they've been conspicuously quiet about the disinformation, misinformation bill, because that should be coming up for review as well. So, when I was young, weird peeps found their people and committed self-yeeting in Minecraft. They didn't impose themselves on others. Yeah. 1,400 pages, so no titty ball. Titty ball isn't tonight. If you're expecting titty ball right now, it's tomorrow. Same time, but tomorrow. Because let's face it, Vices is plastered out of his mind. So sent the link is like 11. That's all of Title IX. Oh. No, I don't think it is. I don't think that's all of Title IX. Executive summary, purpose of the regulation action. Oh, okay. Hang on, wait. Action. Yeah, no, based on extensive review of 2020 amendments, information including stakeholder feedback received prior to the issuance of the notice of proposed rulemaking, consideration of the public, blah, blah, blah. Okay, so no, that's just the explanatory memorandum. Let me have a look, see. Ignore this warning and continue. I'm trusting you with this redirection, Stingy. Page you're on is trying to send you to an invalid URL. If you don't want to visit that page and return to the previous page. It didn't work, Stinge. Are you able to try and resend it, maybe? That's all right. You know what? I'll move on. I can move on. That, because I mean, I'll have to read through that at some stage, but I'm not going to do it tonight. That's way too much for me right at the second. So, try the link on Discord you sent. What's my suggestion? Fucked if I know at this point. Where do I start without winding up This is how ridiculous and how pathetic it is. Where do I start without ending sounding like a conspiracy theorist or someone that's being radicalized against the left? And then I get called all sorts of names and I get disregarded and whatever else because, what's that? We live till we die. Simples have fun, fish, swim and die. You left out fuck. But yes. Try the second link you just sent. Where'd Discord go? Hang on. Actually, have I even got Discord open? I don't believe I do. You can't, that's the point. I think you're probably right on that. Just wait, I'll let Discord open. What's that? That is... Oh, that's much better. Okay. Thank you for that, Stingy. That is helpful. Brief overview of the key provisions of the Department of Education's final rule. The definitions. Adds and revises definitions including complaint, complainant, respondent and party, confidential employee, disciplinary sanctions, pregnancy and or related conditions, relevant remedies, retaliation or peer retaliation, sex-based harassment and supportive measures. Clarifies that a recipient must comply with Title IX and final regulations in the event of a conflict of state law or FERPA, and that Title IX and the final regulations do not override any legal right of a parent, guardian, or other authorized legal representative to act on behalf of the complainant, respondent, or other person. Catesby was saying that I can't have a go at the situation without sounding like a lunatic. Because that's how far we've been pushed into a corner. Long story short, Biden regimes remove civil rights. It really seems that way, yeah. Scope of sex discrimination clarifies sex discrimination includes discrimination based on sex stereotypes, sex characteristics, pregnancy or related conditions, sexual orientation, and gender identity. Also clarifies that sex-based harassment includes harassment on these bases, and further clarifies that sex-based harassment creates a hostile environment. Hang on, so is this all changes to Section 106? Okay, I wonder if I can just... Section 106 application... Hopefully I didn't just give someone a seizure. Okay, scope of conduct of subject. Several commenters suggested replacing conduct that may constitute sex discrimination under Title IX is proposed with conduct the employee reasonably believes constitutes sexual discrimination under Title IX. Wow! Talk about making it open-ended and vague. So it's not whether or not it is conduct that may constitute sexual discrimination, it's conduct that someone subjectively believes may constitute sexual discrimination. You know, that works both ways. Just saying. I mean, if all of a sudden it's a conservative Christian individual that believes that hand-holding or... I don't like this. Saying, yes, sir, how can I help you when it's a man in a dress is not sexual discrimination, according to Bush. What's the alternative? Who else do our ladies brown up to? I don't know. I'm actually getting worn down. Like, to the point where, at some point, very soon, I'm going to throw my arms in the air and say, fuck it, what are we supposed to do? Alright. Clarifies Title IX applies to all sex discrimination occurring under a recipient's education program or activity in the United States. It provides additional detail about what conduct is covered. Also clarifies that a recipient has obligations to address a sex-based hostile environment under its education program or activity, even when some conduct alleged to be contributing to the hostile environment occurred outside the recipient's education program or activity or outside of the United States. What the fuck? A recipient has an obligation to address a hostile environment, even if some of the conduct that's contributed to it is outside their purview. This is the part of the bill where an XIX can just claim discrimination with investigation or facing the accuser. I'm assuming I'll get to that at some point here. Clarifies that a recipient must not Must not separate or treat any person differently based on sex in a manner that subjects them to more than de minimis harm, except in the limited specified circumstances permitted by Title IX. Recognizes that preventing a person from participating in the recipient's education program or activity consistent with their gender identity subjects that person to more harm than de minimis. Recognizes that preventing a person from participating in a recipient's education project or activity consistent with their gender identity subjects that person. Literally, so Title IX now specifically says if you do this, you are causing a certain level of harm to somebody. They've introduced strict liability. Prohibits a recipient from treating students, employees, or applicants different based on sex in connection with parental, family, or marital status. Okay. Prohibits discrimination against students, employees, or applicants based on pregnancy or related conditions, and requires recipients to take actions to prevent sex discrimination and ensure equal access to the recipient's education program or activity, such as providing reasonable modifications for students, reasonable break time for lactation for employees, and lactation space for students and employees. Prohibits schools from requiring documentation from students to obtain reasonable modifications or other actions unless such documentation is necessary and reasonable. So they can just claim crap and without any... Do I need to point out that based on this, take the scenario with Laura Owens and the tonsil twins. If this had happened while she was at school, they're saying that the school would have to take it at face value without any documentation whatsoever. Can someone explain that to me? How or why that's supposed to work that way? Clarifies the recipient's obligation to inform students of rights related to pregnancy or related conditions. Sets out the steps the recipient must require its Title IX coordinator to take when the recipient has knowledge of conduct that reasonably may constitute discrimination, including offering and coordinating supportive measures, when to initiate a complaint, and to taking prompt and effective action to end discrimination and prevent its recurrence. This provision also permits a recipient to offer an informal resolution process, except where a complaint includes allegations that an employee engaged in sex-based harassment of an elementary school or secondary school student, or if such a process would conflict with state, federal, or local laws. In addition, this provision prohibits a recipient from disclosing personally identifiable information obtained while complying with this part, except in limited circumstances. Holy crap, look at the grievance procedure they've put in. No investigation, no repercussions, no proof, expelled, fired, removed from community without trial or ability to face the accuser. Okay, grievance procedures. So presumably this is where the stuff that we're talking about is going to come into play. I'm just going to turn this down a little bit because the closer I keep getting to the light, the more like loud and washed out my face looks. Do you think this would have happened if we did not have Brovid? At some point, yeah, probably. I think this probably just moved the time frame up. Requires grievance procedures for all discrimination complaints that include the following requirements. Equitable treatment of complainants and respondents. So far, so good. Conflict of interest and bias-free Title IX coordinators, investigators, and decision-makers. So far, so good. Presumption that the respondent is not responsible until a determination is made. Presumption of innocence. So far, so good. Reasonably prompt timeframes for all major stages. Okay. Reasonable steps to protect the privacy of all parties and witnesses during the grievance procedures. Objective evaluation of all relevant evidence and the exclusion of impermissible evidence. Okay, don't mind how they're phrasing that. All right. If a recipient adopts procedures that apply to the resolution of only some complaints, articulate principles for how the recipient will determine which procedures apply. Notice of allegations of the parties. Permitted dismissals in certain circumstances so long as the recipient offers an appeal and, as appropriate, supportive measures and takes other steps to ensure that discrimination does not continue or reoccur. Permitted consolidation of complaints in certain circumstances. Burden on the recipient Burden is on the recipient to gather evidence and decide what is relevant and impermissible. That I don't like. Never head towards the light. Burden is on the recipient. So the burden is on the school or the scouts group or whoever is in charge of the activity that is covered by Title IX. The burden is on them to gather the evidence and determine what is or isn't relevant or admissible. That's not okay. It's literally a kangaroo court. No, so this is this is a difference between the adversarial process and the inquisitorial process, okay? So here's the thing. I get to do a little bit of legal teaching here. I'm actually okay with this. Across the world, there are two different types of courts. The adversarial process, which is the same process that here in Australia we have, that they use in the UK, and that you guys use in the US for the most part. That is the judge, although they may be the finder of law, in certain instances they're the finder of fact based on the evidence that is provided to them. They are an impartial adjudicator. They're not the ones that are getting in the face of either party and asking questions. In the inquisitorial system, which is used in certain South American countries, which is used in certain European countries, the judge is the one sitting there asking the questions of the parties. They're the ones making determinations about what is relevant and what should be admitted and what should not. I can understand that there are certain places where the where the inquisitorial system is appropriate. 8 out of 10 times, though, it's not. Because it will almost always revolve around whether or not the judge has bias or not. And you can't do shit all about it. Armadillo Cordy from the Southwest. Burden of proof cannot be placed on the accused. Boosh, you're not listening. The burden of proof is not being placed on the accused. They're placing it on an independent third party, which is just as bad, but you're still wrong, mate. It's the recipient of the notice, not the accused. Rulings have more to do with how much coffee the judges have had. Yes, and that's why the inquisitorial system sucks, because they did some what do you call it? They did surveys and studies and that sort of thing. Oh God, going on 10 years ago, as to when it was best to actually go before a judge to do a case. And they determined that obviously for very specific reasons, the best time to go in front of a criminal judge is first thing in the morning or straight after lunch. You do not want to be the person taking your case to the judge right before lunch or right before the end of the day. Because then their own personal biases come into it. Not only because, if something's going on, the judge will get pissy because all of a sudden they can't go home right on the dot of 5, or worse, they'll rush through the case to make sure that they do get to go home on the dot of 5. No, but you know what? Never mind. I'm not going to go around in circles. Okay. Notice of allegations of the parties. Permitted dismissal certain. Burden on the recipient to gather information, gather evidence, and decide what's relevant and impermissible. Equal opportunity for the parties to present fact, witnesses, and other evidence. Okay. Equal opportunity for the parties to access the relevant and not otherwise impermissible evidence or an accurate An accurate description of the evidence. If the recipient provides access to a description, it must provide the access to the underlying evidence upon the request of any party. A reasonable opportunity to respond and a requirement that the recipient take reasonable steps to provide and address unauthorized disclosures. I don't like the phrasing here. It's even worse. Time after time, we've seen the bias of people running through farcical tribunals and they appoint the advocate for the accused. It's like the lead prosecutor appointing the defense. Yes. Process for assessing the credibility when credibility is in dispute and relevant. Use of a preponderance of evidence standard of proof to determine whether sex discrimination occurred, unless the clear and convincing evidence standard is used in all other comparable proceedings, in which case that standard may be used. This is just a dry run to change the justice system. Kind of feels like it. That's certainly what it feels like, yeah. So on the preponderance of the evidence, so you're 50% more likely to have occurred than not, is required to be used as proof to determine whether or not sexual discrimination has occurred, unless clear and convincing evidence is used in all other comparable proceedings. Sun was out yesterday, now it's raining again today, it sucks. They're taking away due process. That's exactly what they're doing. If it's determined that sex discrimination occurred, remedies for the complainant or others, disciplinary sanctions for those found responsible, and other appropriate prompt or effective means to ensure that sex discrimination does not continue or reoccur. An appeal process is at least the same as those offered in comparable proceedings. I don't like the phrase comparable proceedings either. Equal application of any additional provisions of the parties. Option for parties to participate in informal resolution process if available. Additional requirements for grievance procedures involving a post-secondary student. Written notice to the parties of allegations, dismissal, delays, meetings, and proceedings. Equal opportunity for each party to have an advisor of their choice. Equal opportunity to access the relevant and not otherwise impermissible evidence or an investigative written report. And if the institution provides access to an investigative report, it must provide access to the underlying evidence upon the request of any party. A reasonable opportunity to respond, and the requirement that the recipient take reasonable steps to prevent and address unauthorized disclosures. Process for assessing credibility. They're trying to gloss over the strict rules that we would otherwise have in formal proceedings. They're trying to say what they're trying to say is we're going to preserve due process, but we're going to leave things so vague that by doing so, we were able to basically dot the I's and cross the T's in the most minimal way possible. It's been broken, the Biden regime's snapping it off, apparently. A process for assessing credibility when credibility is in dispute and relevant, including questioning a party or witness during individual meetings or at a live hearing. The recipient opts to provide a live hearing, procedures for such hearing, written determination. Who wrote this? Who put out this chart? Because I need to know whether or not I should be taking this at face value or not. More comprehensive explanation of the final regulations. See the department's notice of final which I'm sure is going to be that great big long 1,300-page document. Page not found. Ruh-roh. Due process, the government decides what rights you're allowed. It's pretty much what it looks like it's boiling down to. Is this one based on one's interpretation? Pretty much, yeah. It's passed into law this week. Oh, wrong button. Where a recipient opts to provide a live hearing, procedures for such hearing, written determination, opportunity to appeal decision. To whom? Clarifies that a recipient must prohibit retaliation, including peer retaliation, and must respond to conduct that reasonably may constitute retaliation, using the same procedures that it uses for other forms of discrimination. I'm gonna have to go through and read it. Because how open-ended, the way that this document can be interpreted has so many different avenues. It's from .gov, US Department of Justice, where I got it. Okay. That's yeah. So I need to be treating this very carefully. Prohibit peer retaliatory acts. Yes. Which means that if somebody claims discrimination against, so say party A claims discrimination against party B. If party C does anything in retaliation against party A, then theoretically, party C is then now subject to the exact same set of procedures as if it was sex discrimination. I mean, presumably the retaliation would still need to be in the form of some sort of, but from the sounds of it, they're attributing it to being sex discrimination if they retaliate on the basis of discrimination. That's a straw man to me. Like, that's... know what it means, it's all bullcrap. Clarifying the scope of sex discrimination. The final regulations clarify that sex discrimination includes discrimination on sex stereotypes, sex characteristics, pregnancy or other related conditions, sexual orientation, and gender identity. Sex-based harassment is a form of discrimination, means harassment or sexual harassment or other harassment on the basis of sex, including on the basis described in subsection 106.10, which takes the form of quid pro quo harassment, where an employee conditions a benefit on a person's participation in unwelcome sexual conduct. Specific offences such as sexual assault, violence, DV, and stalking, and or hostile environmental harassment. Final regulations define hostile environment harassment as unwelcome sex-based conduct that, based on the totality of the circumstances, is subjective and objectively offensive, and is so severe or pervasive that it limits and denies the person's ability to participate in or benefit from the recipient's education program or activity. The 2020 amendments at 106.30a cover sexual harassment, but do not address other forms of sex-based harassment, and prohibit unwelcome sex-based conduct only if it is so severe and pervasive and objectively offensive that it denies a person. So they've inserted that it's now subjectively and objectively offensive. What's the point of leaving objectively in there? If it's going to be subjective to the individual, either the recipient of the notice to say that someone feels that they've been sexually harassed, or it's subjectively based on the recipient that is claiming that they've been sexually harassed, what's the point of saying that it's objectively offensive? Oh, because if something's objectively offensive, it's just so blatantly obvious that it must be. It's intentionally vague? Yes, it is. It's also contradictory. Title IX requires a recipient to address all discrimination occurring under its education program or activity in the United States. Under the final regulations, conduct that occurs under the recipient's education program or activity includes but not limited to conduct that occurs in any building owned or controlled by a student organization that is officially recognized by a post-secondary institution, and conduct that is subject to the recipient's disciplinary authority. Under the final regulations, a recipient is required to address hostile environments in its education program or activity in the United States, even when some of the conduct alleged to be contributed to the hostile environment occurred outside the education program or activity or outside the United States. Probably don't know the definition of the words. Oh no, bye friends. I would be willing to bet that they know exactly what they've done. A recipient with knowledge of conduct that reasonably may constitute discrimination in its education program must respond promptly and effectively. The recipient must also take actions outlined in section 106.44b to K to address discrimination in the education program or activity. The final regulations obligate a recipient to require certain employees to notify the Title IX coordinator when the employees have information about conduct. They put mandatory reporting in. Why? Why would you put... The law is sus. It really is. Obligate a recipient to require certain employees to notify the Title IX coordinator when the employees have information about conduct that reasonably may constitute discrimination. So basically, a teacher, for example, in a government school now has mandatory reporting obligations to report when a student may engage in sexual harassment that is subjective. Good God. Opening up to how vague this is. Okay, I'm gonna say this to the camera, and I'm gonna say this point blank. Parents of males, for God's sakes, point this out to your kids. Because theoretically, this would require a teacher to mandatory report if they wolf whistle at a female student. And I can only imagine what a sexual harassment thing would do on a college application. And you know what? Probably parents of ladies maybe have the conversation too. I'm just saying that it, to me, as a male myself, I feel like this is far more skewed against them because we still have this whole thing in society that boys will be boys and act in certain ways. I don't like the language you're using in chat. It's sexually discriminating against me because sus grounds like cis, and I'm not cis. You're fired. Well, look, thankfully I'm not covered by Title IX, so I don't have to report any of it. So, new generation wonders why guys don't talk to them anymore. Wait till this really kicks in. If Aussie Overlaw'd takes issue with my claim, he'll be sued. That's what. That's this bill. My daughter's 32, stepdaughter's 27. I have 3 grandchildren. Well, make sure you let them know. This ensures that a recipient learns of possible sex discrimination so it can operate its education program or activity free from prohibited discrimination as Title IX requires. Any non-confidential employee at an elementary school or secondary school is obligated to notify the Title IX coordinator. What is classed as a confidential employee? The bitch about incels, wait till they get femcells. Huh? This is insanity. Please note that elementary school and secondary school employees may have additional obligations under federal, state, and local law to report sex-based misconduct. This will make you want to move to the US, right? Nope. Too much sex stuff. This is how the wood chipper recipients work. Yeah. Any non-confidential employee at a post-secondary institution or other recipient who either has authority to take corrective action on behalf of the recipient or has responsibility for administrative leadership, teaching, or advising in the recipient's education program or activity is obligated to notify the Title IX coordinator. All other non-confidential employees at a post-secondary institution or other recipient are obligated to either notify the Title IX coordinator or provide the contact information of the Title IX coordinator and information about how to make a complaint of discrimination to any person who provides the employee with information about conduct that reasonably may constitute sex discrimination. Next, the US is going to roll out climate camps. Under the final regulations, a recipient must also require its Title IX coordinator to monitor the recipient's education program or activity for barriers to reporting information about conduct that reasonably may constitute sex discrimination and take steps reasonably calculated to address such barriers. I think this might be the one that got Bush's knickers in a twist. To ensure that a recipient's education program or activity is free from discrimination while also respecting complainant autonomy, the final regulations require a recipient to provide clear information and training on when their employees must notify the Title IX coordinator about conduct that may reasonably constitute sex discrimination and how students can seek confidential assistance or make the complaint of sexual discrimination, requiring the recipient to initiate the grievance procedures. The final regulations identify 3 categories of confidential employees who are not required to notify the Title IX coordinator about conduct that reasonably may constitute discrimination. Instead, these employees must provide information to anyone who informs the confidential employee of conduct that reasonably may constitute sex discrimination based on the status as confidential for the purposes of Title IX, how to contact the Title IX coordinator and how to make a complaint, and how the coordinator can help. A complainant is also protected in their right to make the complaint about sex discrimination they've experienced, even if they have chosen to leave the recipient's education program or activity as a result of that discrimination or for other reasons. I'm sitting so hard on the fence on that one, I've got splinters in my ass. Because legitimate complaints should be reported. But I've got a devil's advocate everything. You know that. I try and look at I try and look for the worst possible scenario out of things. And basically, if someone, for example, were to get kicked out or expelled from a school or for any number of other things, they could still make a complaint maliciously. And based on the vagueness of some of this wording, good time to be an introvert, stay away from everyone and keep mouth closed, fingers away from the keyboard. Oops, fingers have taken on a life of their own. That works. For goodness sake, never took offense to anything he said. To anything who said. That's called lawyering, devil's advocate? Yeah. So many lawsuits going on in this world today, from murder to stalking, it's ridiculous. Wait until the first female is accused, watch how fast they backtrack this entire rule. I don't know that they will, but Jason, because it's... I'm getting you confused now. Oh, look out, you might make a complaint about me. Because I kind of feel like everything that I've seen, they're looking to destroy females just as much as males. So... start dragging these women in every time they look or speak at you, play them at their own game. No, they'll attack the real females with it if they speak out about individuals that I cannot mention. In the absence of a complaint, or the withdrawal of any and all allegations in the complaint, and in the absence or termination of the informal resolution process, the Title IX coordinator may initiate a complaint only if the conduct presents an imminent and serious threat to someone's health or safety, or prevents the recipient from ensuring equal access based on sex to its education program or activity. Together, these requirements in the FIDA regulations ensure that employees and students have information. Employees and students in elementary schools and secondary schools know that all non-confidential employees must notify the Title IX coordinator of conduct that reasonably may constitute discrimination. Employees and students at post-secondary institutions know that certain non-confidential employees have a duty to notify. Students and parents, guardians, and other authorised legal representatives of elementary and secondary school students know how to make a complaint to initiate the recipient's grievance procedure, and also how to seek information about supportive measures and other resources. The recipient knows to honour a complainant's request not to proceed with a complaint investigation unless the Title IX coordinator makes a fact-specific determination that the... Okay, so basically they're saying, if whoever makes the allegation decides to pull the plug, the Title IX coordinator can still proceed, but only if there is an imminent and serious threat. I suppose that's something. Title IX coordinator, well, great. How about a regular person? Under the final regulations, a recipient with knowledge of conduct that may reasonably constitute discrimination in its education program or activity must respond promptly and effectively. Final regulations provide that the recipient must require its Title IX coordinator or a designee to take the following actions upon being notified. Okay, so you've got mandatory reporting to the... Okay, so let's boil this down. Let's take the example of an elementary school. No, we'll go secondary school. 16-year-old boy wolf whistles at a 16-year-old girl. As a result, a teacher in the schoolyard sees it, is then obligated to contact the Title IX coordinator. Now, what does the Title IX coordinator actually go through? Treat the complainant and respondent equitably. Oh, it's not equally, it's equitably. Treat them equitably. Offer and coordinate supportive measures as appropriate for the complainant. If the recipient has initiated the grievance procedures or offered an informal resolution process to the respondent, offer and coordinate supportive measures as appropriate for the respondent. Notify that the complainant, or if the complainant is unknown, the individual who reported the conduct of the grievance procedure and the informal resolution process. If a complaint is made, notify the respondent of the grievance procedures and the informal resolution process if available and appropriate. In response to a complaint, initiate the recipient's grievance procedures or informal resolution process if available and appropriate. 16-year-old boy then goes to re-education camp and is sentenced to hard labour and removed from school. Pretty much. Hang on, where is my... Oh, there it is. No! I didn't mean to close that. I completely forgot that I still had the board on. That's funny. Have to kill me first. Hello, how you doing? Alright, so I'll just let Social Blade update. Where are we? In the absence of a complaint or withdrawal of any of all the allegations of the complaint, in the absence of termination of informal resolution process, make a fact-specific determination by considering at minimum 8 listed factors and determining whether the conduct as alleged presents an imminent and a serious threat to the health and safety of the complainant or other person, or prevents the recipient from ensuring equal access to based on sexual segregation education program or activity. If the coordinator initiates a complaint, notify the complainant prior to doing so and appropriately address reasonable concerns about the complainant's safety or the safety of others. Regardless of whether a complaint is initiated, take other appropriate, prompt, and effective measures to ensure that discrimination does not continue or reoccur within the recipient's education program or activity. So if a 13-year-old white male calls a 13-year-old... The white kid is expelled for equity purposes without anything. Certainly what it sounds like. Like, don't get me wrong, this could all be just like a massive beat up. I won't know until I actually sit and read through the freaking amendments to Title 9. I would love for a US attorney to read through this with me. Don't know who would have the time, but... where are we? Final regulations require a recipient to offer and coordinate supportive measures for the parties appropriate to restore and preserve each person's access to the recipient's education program or activity and provide support during the grievance procedures or during the informal process. Let's take the secondary school example again. 16-year-old boy, wolf whistles at 16-year-old girl. Teacher smacks 16-year-old boy up the side of the head and says, "Don't do that." End of story. Like, don't get me wrong, teachers aren't supposed to lay hands on kids anymore, but maybe that needs to be reinstituted. I don't know. Lower level of equity recipient says anything to anyone not at their equity level. They can be expelled, fired, excommunicated, kicked out, etc. Does seem to be... Final regulations permit a recipient to offer an informal resolution process if appropriate, wherever it receives a complaint of discrimination or has information about the conduct. Participation in informal resolution must be voluntary. It's not permitted in situations where an employee allegedly engaged in harassment of an elementary school or a secondary school student, or if the process would conflict with federal, state, or local law. Okay. So maybe, depending on what the informal resolution process is, it could be just that. Catholic school would be like that, wouldn't it? You can always hope. She's going to say teachers aren't supposed to put their hands on any kids. Yeah. Went to school and quit when you were 16. Damn, okay. Okay, I feel like I already read through this. Grievance procedures for all complaints. Equitable treatment of the complainants and respondents. Title 9 investigators, decision makers that must have no conflict of interest or bias. Prompt time frames. Notice of allegations, dismissals, consolidation permitted for complaints. Burden is on the recipient to gather the evidence. Subsection 1651. I'll save that one for later. Equal opportunity for all parties to present fact witnesses and other inculpatory and exculpatory evidence as is relevant, not otherwise impermissible. That contradicts what they've specifically said about it, though. When your daughter was 2, you went back to school and got your high school diploma. Good on you. Said that the teacher was egging 2 kids to fight, saying, "Get him" and shit. No shit, really? Did not know that. Process that enables a decision maker to question parties and witnesses to adequately assess a party's or witness's credibility when credibility is in dispute. Clear processes, determining sex discrimination. Okay, so this is more or less the same as what the previous one was. Notice, that's fine. Permitting questioning, proving questions. Wait, hang on. Process enabling decision maker to question parties and witnesses to adequately assess a party's or witness's credibility when credibility is in dispute or relevant. When a post-secondary institution chooses not to conduct a live hearing that includes allowing the investigator or decision maker to ask relevant... Yeah, see, like I said, they're heading to the inquisitorial system as opposed to the adversarial. It's literally, you're going to have, for example, the Title IX coordinator, or for lack of a better, for lack of anyone else, a school principal or a vice principal or someone sitting there asking questions that may or may not get to the heart of the matter. This is not appropriate. Teacher that organised a fight club with special needs kids. No shit. Whoa, that's not great. Allowing each party to propose relevant and not otherwise impermissible questions that the party wants asked of any party or witnesses, and have those questions asked by the decision maker or investigator during individual hearings, including follow-up meetings. You will continue to have the right to confront your accuser, but it will be done through a third party without you present. Providing each party with audio or audio-visual recordings or a transcript with enough time for the party to have reasonable opportunity to propose follow-up questions. When a post-secondary institution chooses to conduct a live hearing, that includes allowing the decision-maker to ask relevant questions and not otherwise impermissible questions during the live hearing, and allowing each party to propose relevant or not otherwise impermissible questions that the party wants asked of any party or witnesses, and have these questions asked during the live hearing by the decision-maker, or allowing an advisor for each party to ask relevant. So you can have representation provided it's in post-secondary. So if you're in elementary or secondary school, you're fucked. Having an advisor for each party to ask relevant questions is not otherwise impermissible. Permitting but not requiring a live hearing. When a live hearing is provided, the recipient must allow the parties on request to participate from separate locations using technology and create an audio or visual recording or transcript of any live hearing and make it available for parties for inspection and review. Prohibiting questions that are unclear or harassing of the party being questioned. Permitting a decision maker to weigh the credibility of a party. More brainwashing, stop going to colleges and universities. I know trade workers have more and more free time than degree-based jobs. Let's just call them the Grand Inquisitor. That's what they really are. That's pretty much what it's boiling down to. Like, I'm sorry, but saying that that it's going to be a decision maker, nowhere so far have I seen that this decision maker is going to have any form of legal qualifications whatsoever. If all it is the Title IX coordinator for whatever the institution is, you'll be lucky if they have an education degree. But no, they're supposed to wade through. Simultaneously providing written notes to the parties of the determination that includes a description of the allegations, information about the policies and procedures used to evaluate the allegations, the decision maker's evaluation of the relevant, not otherwise impermissible evidence, and determination of whether sex-based harassment occurred, disciplinary sanctions and remedies if relevant, and any information about appeal procedures. Opportunity to appeal a dismissal or determination based on procedural irregularity that would change the outcome, new evidence that would change the outcome or that was not reasonably available when the determination or dismissal was made, and conflict of interest or bias, as well as other bases offered equally up to the parties by the recipients. Oh, how much more of this is there? Okay. Final regulations require a recipient to prohibit retaliation, including peer retaliation, and respond to information and complaints involving conduct that reasonably may constitute retaliation using the same procedures it uses and some for other forms of discrimination. Retaliation is defined as intimidation, threats, coercion, or discrimination against any person by the recipient. To provide aid to, benefit, or service under the recipient's education for the purpose of interfering with any right or privilege secured by Title IX or the regulations, or because the person has reported possible sex discrimination. So, hey, Tim Pool's Go Music. I'm alright. How you doing? So basically what this boils down to is, for example, if Party A claims that Party B sexually discriminated against them in some way, shape, or form, and then Parties C, D, E, and F, who were supposed to be in, say, a project group at university with A and B, then decide they want nothing to do with A because they don't believe the allegations or anything like that, they are then they could then be classed as having discriminated against them and engaging in retaliatory conduct. Teacher encouraged fights was Julius Jonican, for anyone who wants to search the article. Cheers, appreciate that. Put my son in private school after his 6th grade year. My wife really pushed for it and I don't regret it. Fair enough, boyfriends. You know, I'm going to take this very brief moment at the hour and 15 mark. Guys, if you haven't already, feel free to hit that like button. And if you're new here, if you're enjoying the content, maybe just think about hitting the sub button. I am really hoping to get over the 32,000 mark at some point. Time in public schools was a very violent experience. Jesus. Pure retaliation, which is defined as retaliation by one student against another, is also prohibited. Final regulations clarify that nothing in the regulations precludes a recipient from requiring an employee or other person authorized by the recipient to provide aid, benefit, or service under the recipient's education program or activity to participate as a witness in or otherwise assist with a Title IX investigation. I'm not so much fussed about the stuff about the discrimination based on pregnancy, because I kind of feel like that's reasonably justified. Recipient must not require supporting documentation from a student unless doing so is necessary and reasonable. For example, a recipient must not require documentation when it's already been provided or relates to lactation needs. That's kind of fair. It is obvious or one of various routine and simple modifications as set forth, or modifications, leave, or other steps are available to students for non-pregnancy related reasons without submitting and supporting documentation. Yeah. Just Google special needs Fight Club, it'll come up all over. No more videos of girl sports teams refusing to play. Yeah, that's covered by this. Okay, this is the issue that I have, the de minimis harm. Because basically what this is saying is that if they engage in any conduct, at least said conduct. How do I phrase this? Okay, let's take the example of the sports team. If, for example, a sports team of girls walks away and decides they're not going to play against another team, so Team A walks away, Team A is alleged to have at least, if they're found to have committed discrimination, they are found to have committed at least this level of discrimination. De minimis, higher than de minimis, and they're already saying that if they're found, it's automatically over that threshold. General prohibition on more than de minimis harm, application of policies and practices that prevent participation consistent with gender identity. The final regulations prohibit a recipient from separating or treating any person differently based on sex in a manner that subjects that person to more than de minimis harm, except in the limited circumstances where the statute allows otherwise. Such is the context of sex-separate living facilities and sex-separate athletics teams. Oh, okay. The final regulations clarify that policies... Whoa, hang on. Blood pressure pill donation. Thank you very much, Tim Pool's Game Music, with a rumble rant. Appreciate that. That's what it'll take. They need to refuse or wait till the cheater finishes, then do the girls' race. Brother Gaines is talking about it. Not shocked. Final regulations clarify that policies and practices that prevent a student from participating in a recipient's education program or activity consistent with their gender identity imposes more than de minimis harm on that student on the basis of sex, and therefore generally violates Title IX's non-discrimination mandate. The department intends to issue a separate final rule to address Title IX's application to sex-separate athletics teams. We're going to pass the buck because we don't want to have to release this before the election. It's really what that boils down to. And finally, the final regulations prohibit a recipient from disclosing personally identifiable information obtained in the course of complying with Title IX. That's fair. We have that same rule here. We've got the Harmon rule. Basically says any information that's provided in the course of proceedings is not able to be used either externally or in other litigation for that matter. Fine play there, game. Identify as a squirrel and file against everyone that filed against you. Where are we? Obtaining the course of Title IX with limited exceptions such as where the recipient has prior written consent or where the information is disclosed to a parent of a minor. Holy fuck balls. This is a mess. If mothers don't want a grown man showering with their daughters at the YMCA, it's discrimination. Yep. And if you're found to have committed discrimination, you're already found to have if you are found to have met a certain threshold of discrimination. So, that's interesting. And honestly, not where I expected this show to go. So let me see if we can find something a little bit more... Oh, yeah, let's go with this one. It's another Law and Crime article, but hey, have the teacher article if you want it in the DM. Oh, really? Hang on. No shit. shit. Are you serious right now? Shocking video shows moment elementary school teacher orchestrated a fight club and encouraged students to assault each other as he egged them on. You get him. Oh my god. Shocking video shows the moment an elementary school student pummeled a special needs pupil while the teacher encouraged the violence. The furious mother of the 7-year-old victim has launched a lawsuit against George Washington Carver School in Indianapolis over the incident. Corey Horan's lawsuit in Marion County, Indiana, on behalf of her son, accuses teacher Julius Jonican of orchestrating a reprehensible fight club, first rule about fight clubs, you don't talk about fight club, type of discipline within his classroom over the span of 3 months. She became aware of this after he accidentally showed her mobile phone footage of her son, who has ADHD, being beaten by another second grader, according to the suit. Dude, what the fuck is wrong with you? The first rule about Fight Club is you don't talk about Fight Club. The second rule about Fight Club is you don't videotape Fight Club. The third rule is you don't show it to parents. What the fuck is wrong with you? Not that I'm condoning it. This is tongue in cheek, obviously. Like, what the fuck? Sounds like some hood stuff. Sorry, I was looking at that. I couldn't work out who Tricky Rich was talking about. Hang on, what's this? He's gonna need him. Cool with the furries if we can hunt them. Should put a few zeros on the end, or we can just watch his face go bright red before his head explodes. YouTube is asshole. Yeah, well. Hey, I appreciate each and every one of you being here. Get the fucking chainsaw ready. Anyone else think Hayden's volume's a tad low? It does look like it's a tad low. It could just be that I don't have the mic positioned as well as it did, or it could just be that I'm actually not 100% sure. For some reason, I'm coming up a little bit low. But that could just be, like I said, when I started this, I was having issues with the Rodecaster. So fingers crossed. Because I can't really boost it anymore. Hey, Daily Quick Bites, how you doing? You're half death. Fair enough. The attacker can be heard saying, "Don't mess with me," while throwing punches as her son cries on the ground. Holy shit. And the second grade teacher shouts, "You get him." Oh my god.
You let go of me.
You guys done?
Are you guys done? Did you cover the centrist fellow who got lit yesterday? No, look, I haven't specifically talked about that. I mean, he's passed, unfortunately. It's sort of like, well, what did we really expect to happen? I'm unsure as to how much of this I can actually show on YouTube. Indianapolis Public Schools, which is the defendant in the lawsuit, said in a statement that it does not tolerate any type of behavior alleged in the complaint and takes reports of potential abuse and neglect seriously. The school principal, vice principal, superintendent, and school board are also named as defendants, and the Daily Mail has contacted each for comment, and presumably did not receive any comment prior to publishing. Holy damn, is that the teacher? Yes. Oh, he wasn't a centrist. Lots of Dem donations in his history. No shit. That guy really roasted himself. That's bad, Jason. Was that intended as a joke? If it was intended as a joke, that's bad. Horan says the fight video is only the tip of the iceberg. Her son, known only as OD. Oh, come on. What was her name? I mean, I get that he might have his father's surname, but why would you... For those of you that know me, you know exactly where my mind just jumped to. Was not intended as a joke? Okay. Within the... OD had been complaining of bullying and abuse in the classroom dating back to August 23. Within the first few weeks of school, OD began to come home sad and upset behaviorally dysregulated and reporting abuse, bullying, and classroom harassment. Outlining Jonathan's Fight Club, the suit adds, in a horrifying setup, he not only permitted but incited and facilitated other students to engage in acts of violence against the 7-year-old OD. You have a kid that name's worked out to OD. No, see, here's the thing. If it's a pseudonym, it's randomly applied. If they chose to put that in the fucking pleading, that's on them. Because here, if you apply to the court to have a pseudonym applied, they may or may not randomly assign it. I don't know how it works over there. If her lawyer has actually put it in the pleading that he's referred to by the pseudonym of OD, that's really bad. It says the problems included at least 3 beatings and various forms of physical harm and bullying, both for his own amusement or as deeply disturbed disciplinary measures. This systemic abuse occurred within the school premises and within OD's classroom, a place where a 7-year-old disabled OD should have been nurtured and protected, not subjected to repeated and organised violence. The lawsuit stresses Jonathan encouraged behaviour which went beyond mere pushing or shoving by orchestrating physical assaults. OD was thrown to the ground, struck, slapped, and hit in the head repeatedly, the suit says. On 2 occasions, it's reported that he, Jonathan, held OD while allowing other students to punch, hit, and kick him. I'm going to go outside. I'll be back in a minute. I need to gas up the wood chipper and just make sure it's well lubricated, okay? I guess he had prescriptions to deal with in reality. He never learned how to deal with reality. Not opposed to kids horsing around, but this obviously isn't that. No, that's where my mind went. If the kids are sort of rough and tumble tussling to, like, you know, kids will be kids. Him holding on to the kid so they can beat him up is not that. Wait, what was that? Kangaroo Fight Club Dono. Thank you, Tim Pool's game music, for that one. Alright, what did I get to? Lawsuit stresses that Jonathan encouraged behaviour that went beyond mere pushing or shoving by orchestrating the physical assaults. Jonathan also made continuous threats to the boy and subjected him to deliberate humiliation, according to his mother. What a piece of shit. Got an idea. I'll hold the teacher, you'll take turns. Sound good? Yeah, sounds pretty damn good to me, actually. She said it led her child to developing a profound anxiety specifically related to the school environment. His grades fell and he began to plead with her to let him skip school. Substitute teacher Pardeep Dhaliwal was also present in the classroom during the attacks. We had teachers that would toss you across the room, toss you across the hallway to break up a fight. There was another adult in the room. On top of the alleged hostile campaign against her child by Jonathan, the pupil was also subjected to discriminatory conduct from another unnamed teacher. OD told his mother that a teacher working with Mr. Jonathan said that special needs students were demonically possessed. The child said staff told him he was bad and needed holy water poured on him to cure him of his evil. Horan said she arranged meetings with Jonathan about her son's worries, but he dismissed them and indicated that OD was lying or mentally ill. The teacher repeatedly suggested that OD was fabricating stories as part of an escalating effort to avoid attending school. Don't remember any teacher laying hands on a kid, but I do remember a teacher throwing a desk across the room. Ever seen the vid where Rue grabs a guy's dog and the bloke walks up and punches it in the face? Yeah, I've actually showed it on stream a couple of times. What the fuck? That is all. Disabled, but didn't they say ADHD when it did ADHD become disability? Maybe I heard wrong. Anybody take care of the people that attacked the bishop yet? No. That's still a developing story as well. Where are we? Things reached a head on September 22, 2023 when the school called Horan telling her that OD would not calm down and that she needed to speak with him on the phone. She believed him to be experiencing hyperactivity, but said when he spoke to her on the phone, he was hysterical. She left work and drove to school to find out what was happening and found him upset, traumatized, and shaken. Shockingly, the investigator said that when they questioned the principal, who was also a defendant in the suit, she said the substitute teacher defended the fights. The mum said when she got to the classroom, her son and another pupil were looking at something on Jonathan's phone, but they immediately put it away when she approached. The parent demanded to observe in the classroom and was allowed to stay for approximately 45 minutes. During the entirety of her stay, no one from the school explained to her what had happened with her son's behaviour or the phone call she'd received. Her son walked her to the front of the school doors when she left, and he reported in tears that he was being abused in school. She said on Jonathan's instructions, another pupil had slammed his head down on a desk, pulled him to the floor, and then hit him repeatedly in the head. Terrorist execution. Thank you. And look at that. That puts us a whole 1, 4, 5, 9. We are $41 away from the Labracadabrador. Where are we? Said on Jonathan's instruction, damn. Horan spoke with the vice principal, Finney Rent, that day, but the employee did not follow up with the investigation or provide any additional information. She was repeatedly informed that it was her child who was disruptive, lying, and that there was a sign of disordered personality in the child and related to his ADHD, her lawsuit said. Horan said that tragically she did not believe her own son's accounts of what was happening because they seemed so extreme and were refuted by the school. But this changed on November 1 when she met with Jonathan for a parent-teacher conference, and he accidentally showed her the fighting video on his phone. While attempting to show a video of the class environment, he inadvertently began showing the wrong video. In this one, the parents saw their child being attacked. To say what now, dog? The Labracadabrador. The Labrador. Angel. Who was currently snoozing away by the door to my office. I thought it was clever. A shop teacher was an old comp bodybuilder. Saw him lift somebody by the belt loops and a bowling ball him across the hallway because of... And now I've got that stuck in my head. People have too much time on their hands today. They need to get busy and off their asses. Yep. Horan tried to grab his phone, but as he pulled it away, he accidentally turned up the volume so she could hear him instigating and encouraging the beating of her disabled 7-year-old child. The school secretary was informed and she contacted the Indiana Department of Child Services, who launched an investigation. Shockingly, the investigator said that when questioned Principal Mary Capco, who also is a defendant in the suit, she said that the substitute teacher defended the fights. When asked about the allegations by Capco, Dhaliwal said of the children, several of whom have special needs, they're bad kids, that's what you do, the suit claims. The abuse was also reported by Horan's son to Anthony Bigby, an IPS behavioural consultant, but he took no action. Horan's lawsuit also named Superintendent Alessia Johnson for failing to protect her son from the harms of the school, which was under her supervision. The relentless daily verbal harassment, abuse, and at least 3 documented and substantiated physical attacks and beatings instigated by his teacher had a catastrophic effect on his mental well-being, leading to a marked deterioration in his emotional health. Every day since Biden, things get worse and worse, not just here, it's everywhere. He's a cancer upon the planet. Damn! Thank you very much for that. Liam Neeson used to be a substitute teacher. He punched a student in the face when the student pulled a knife on him. Holy crap. Aussie Tank says, does your dog walk up to you at random and fart? On occasion. She's good like that. The environment created by IPS manifested in escalating symptoms of anxiety.
Every day since Biden, things get worse and worse. Not just here, it's everywhere. He is a cancer upon the planet.
Sometimes I love that, sometimes I don't. Super Nintendo did want. Super Nintendo Chalmers ignored it. She said the actions and inactions of the Indianapolis the public school department had resulted in a profound psychological and emotional trauma for her son. Horan alleges discrimination, negligent care, negligent hiring, retention and supervision, and inadequate policies and protections against the school. Also, YouTube, for the sake of clarity, I would like to specify, this chick in this photo here is not nude. Just saying. She's demanding a jury trial to get justice for her son, and the filing asks for an unspecified amount of money. IPS does not tolerate this type of behaviour alleged in the complaint and takes reports of potential abuse and neglect seriously, IPS said in a statement. When IPS learned of the teacher's conduct, the Department of Children's Services was immediately notified, and the teacher was removed from the classroom and suspended. The teacher had no further contact with students and is no longer employed by IPS. Because of this matter is subject to pending litigation, it is inappropriate to comment further on the investigation of this matter. IPS added that it was not aware of the fights until October 30, when Horan emailed Principal Capco. It said Capco immediately contacted DCS and IPS Human Resources. And they say video games are bad for kids. YouTube's haven't been able to comment. Really? No shit. I don't know what that's about. It's not easy being a kid when all the adults are wackadoo. Yep. That's one way of putting it. Alright. YouTube paused my commenting for 24 hours not that long ago. Guess they didn't like my comment. No shit, can they even do that? Has it happened? I'm in a shop and someone runs up to me yelling, "Daily, daily, hi, daily." And I'm like, "Who the F are you?" In my head, she's like, "It's me, Kim K20. I was floored." Huh! That's funny. Okay. I might forget you, but you won't forget me. 9-year-old kidnapping survivor taunts her captor as he's sentenced. I need to make that shorter. An upstate New York man in his late 40s will spend a prison term equivalent to at least his current age behind bars for the terror and violence he inflicted on a 9-year-old girl last fall. In February, Craig Ross Jr., 47, pled guilty to kidnapping Charlotte Senna from a campsite at Morrow Lake State Park, located roughly 47 miles north of Albany, and essaying her in September 23. Need to make a list of comments I haven't been able to post and drop them in the Discord. You'll get a laugh from the innocuous stuff I've been unable to post. You want to do that? Go for it. During a... Oh, come on. It's too late at night for this shit. Vitupertive sentencing hearing. Victim impact statements excoriated the condemned man for the horrific crime that caught the attention of people and affected officials across the Empire State. YouTube isn't even hiding it anymore. Nope. 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 During the 2 days Charlotte was missing, a ransom note turned up in her family's mailbox. That written demand led to a relatively quick resolution. New York Governor Kathy Hochul, flanked by law enforcement, was the person who announced that a fingerprint on the note matched Ross. He'd been arrested for a DWI in 1999 in Saratoga Springs. He was already in the system, and the fuckwit didn't think to actually wear gloves when writing out a kidnapping note. She's a beautiful, sweet 9-year-old girl, the girl's aunt told the media during the initial search and rescue efforts. She has blonde hair, bangs, and green eyes at just under 5 feet tall. She was last seen riding her bicycle at the park at around 6:15 p.m. on September 30th, 2023, wearing a grey helmet and a Pokemon t-shirt. An Amber Alert was issued the next morning at 9:35 a.m. and cancelled by 6:45 p.m. the day after that. In all, should be gone just over 48 hours. They found her within 48 hours. That is actually fantastic. Where was the fingerprint? It was on the note. It was on the kidnapping note. I'm going to hell, I know. I'll save your seat. One of the very few in New York that actually does their job properly, it seems, and not just act like a mafia stooge. Don't know what to say to that. While over 100 search and rescue professionals combed 46 miles near and around Lake Moreau, the girl was found confined inside a cabinet in Ross's camper parked behind his mother's house in Ballston Spa, some 20 miles southwest of the park where she was abducted. We're thrilled she's home and we understand that the outcome is not what every family gets, her family said in a statement released after the recovery effort. A huge thank you to the FBI, New York State Police, and all the agencies that were mobilized, all of the family's friends and volunteers. But a relatively quick end was small comfort to the girl. During the sentencing hearing on Wednesday, Sarasota County Assistant District Attorney Jennifer L. Buckley read a statement penned by the survivor who did not appear in court herself. Interviewing the note, show me on the paper where the bad man touched you. That's bad. That's bad. Because of you, I can't sleep at night, Charlotte's message read in comments reported by the Associated Press. I was in prison for 2.5 days and now you'll be in prison for 47 years. He was sentenced to spend 25 years to life in prison on one count of kidnapping and sentenced to spend 22 years to life behind bars on one count of predatory SA of a child. The charges were assessed to run consecutively or one after the other. You were haunting my thoughts, but now I will be haunting yours, the prosecutor continued, still speaking for the little girl. Eventually, I might forget you, but you won't forget me. You'll never be able to affect anyone ever again. No, but someone's going to affect him once he hits general population. Just saying. You know, I'm going to play this just because it's entitled Rim Shot. If you know, you know. If you get it, probably shouldn't have laughed at it. Happy to say I don't take any medications on a daily basis. Cool. Off with his head. The S is not a typo. Off with his heads. Okay, gotcha. The length of the sentence suggests that the girl's kidnapper will be likely to die in prison, though there's a small chance for late in life release. He'll be 93 years old when he's eligible to talk about parole consideration, said Sarasota County District Attorney Karen Hagen at a press conference earlier this year. The girl's family also addressed the man who has multiple sclerosis, whose crime changed their lives forever. What kind of a person wakes up in the morning and decides they're going to steal someone's kid? The girl's uncle read. One among many statements from family members. What kind of a monster does that? You, Craig Ross, you did that. You probably thought it was easier to get away with. Look at me. Does it look easy now? I'm glad you got that. Where are we? No, got that. I kind of don't want to get into all of the stuff about the e-safety commissioner and all that sort of stuff. I want to save that for its own episode. We were fined by our homeowners association for parking in our own garage. We fought back and the judge agreed with us, but it took 4 fucking years. A homeowner enlarged their garage and the homeowners association took them to court for $80,000 in damages and legal fees. He said and the judge denied it, saying that the organization's authority to enforce was unenforceable and dismissed the homeowner's deed violations. As well he should. In 2016, the Chang family paid to have the garage in their Houston, Texas home adjusted, sparking a lawsuit from the Garden Oaks Maintenance Organization over deed violations committed from the construction. Excuse me. Austin Barcelo, the lawyer for the association, argued that ensuring certain restrictions are followed strengthens the community. You must do as you are told. It strengthens the community. We won't make it in prison for 2 years, even with COs keeping him in the SHU. Yeah. How old is he now? 47. Deed restrictions are extremely important to neighborhoods in Houston, he told the Chronicle. The group works so hard to enforce them in Garden Oaks, I think you can tell the difference between neighborhoods that enforce it and don't. This neighborhood is successful in part because of it. Oh, bite me. Chang's family attorney at the time said that the organization's power should be called into question. Can they now go back at a neighbor for not mowing the lawn? Are there other deed restrictions at play? The answer is no, he said. How are the rights determined between parties in the future? Do you have the ability to solve those long term? They have no right to enforce deed restrictions at all. The association argued that Chang's garage, being a 4-car garage, violated deed restrictions, and it noted that several attempts to settle were made before the lawsuit was filed in 2012. Never ever buy a property where there's a HOA. They are always full of dipshits and assholes, no exceptions. Abso-friggin-lutely. I'm well and truly, homeowners associations, or as we call them here, owners corporations, are the bane of my existence, particularly in relation to property transactions that I deal with. What's that? Troopers ordered to pay $2.3 million for unconstitutional 2-step traffic policy. How old is that? I feel like that's old, but I'll have a look. Therefore, the HOA sought to have the judge rule to force the family to comply with the deed restrictions while covering the legal fees, totaling around $80,000. Judge Dan Hind ruled in favor after the jury decided that the homeowner was not guilty due to the organization's track record of selective enforcement, as other homeowners have made similar changes without notices of violation. His age is dead in prison. He also denied the organization's plea for $80,000 despite Chang's garage being in clear violation of the deed. The lawyer found 11 examples of deed restrictions being selectively enforced on other homeowners in the subdivision, all close to the house. A home across the street from the Changs made the same change to their home, and they were not penalised or sued. In his final judgment, the trial judge rendered judgment against Gomo, and in favour of the Changs, according to the court documents. The trial court issued 4 declarations and did not award attorney's fees to the Changs. According to the outlet, the HOA is not satisfied with the ruling. An attorney mentioned the judgment would be evaluated to ensure no other options could be explored. Well, duh. How old is this? This was yesterday. Okay. I mean, I know it's the sun, but fuck it. I'm curious. Highway Patrol has to pay up to $2.3 million after officers were doing searches and seizures on vehicles to scope out drug traffickers without reasonable cause. The ordered payment comes after the U.S. District Court Judge Catherine Vrattel declared the Kansas Highway Patrol actions through its Kansas two-step policy were unconstitutional and violated the Fourth Amendment. Isn't this the one that, H, not H, you're an American now? I've always watched way too much American TV, so my vocabulary is, I used to get shit for it in school, as to whether or not I would be classed as speaking Australian or, it was determined by the time I got into 10th grade that I was Australian with an American inflection. If you join a community that doesn't have a HOA but makes one after you join, refuse to join it, abso-freaking-lutely. Because this is the one where the cops do the thing so that they walk towards, but they double back, so that individuals stick their heads out of the car and engage with the police officers, because then they've got a reason to stop and talk. You got a Boston accent? Oh, there you go. Kansas said no, we will continue to violate people's rights. The American Civil Liberties Union of Kansas, the National ACLU, and the Spencer Fane law firm challenged the Kansas Highways Patrol's search and seizures in court in 2020. The $2.3 million will cover attorney's fees for the ACLU and Spencer Fane law firm. It was ordered on Friday. Spencer Fane law firm represented the plaintiffs who challenged the constitutionality of the Kansas two-step policy. Officers doing the Kansas two-step policy would pull people over for basic traffic violations, then ask if the driver would voluntarily ask questions that were unrelated to being pulled over. They were then ordering roadside searches using drug-sniffing dogs depending on the people's answers. Attorneys with the Kansas Highway Patrol argued the searches were how the officers were doing part of their war on drugs. As wars go, this one's relatively easy, Rattle said in court in 2023. It's simple and cheap, and for motorists, it's not a fair fight. In Massachusetts, 20-minute drive to Boston from where I live. Oh, there you go. The war is basically a question of numbers. Stop enough cars and you're bound to discover drugs. So what's the harm with a few constitutional rights being trampled along the way? Big issue. Are you right there? Don't you wag your tail at me. You done? Okay. Moving on. Check General Discord, posted 4 comments that YouTube will not let me post. Alright, give me a second. Put up a fight. A plaintiff with the ACLU received $40,000 in 2023 due to unconstitutional traffic stops. She's only doing it when I talk. Apparently she's had enough of me too. Sharon Brett, former legal director of the ACLU, referred to the Kansas Highway Patrol traffic stops as degrading. These practices turn something minor into a traffic violation into a degrading and lengthy roadside detention. When we give police the power to conduct these pretextual stops, assume people to be drug traffickers, and use flimsy justifications to get inside the vehicles to prolong traffic stops. We turn what should be a simple ticket release scenario into something longer and fraught and complicated. This was an incredibly resource-intensive case, said someone from the ACLU. We are extremely gratified that the district court recognised the value of the tremendous amount of hard work for our entire team of dedicated attorneys and legal staff that was poured into this case over the past 4 years. We believe that such an award serves not only to vindicate our client's pursuit of justice. Huh. Wait, what? Serves not only to vindicate our client's pursuit of justice, but does what as well? Why would you write it like that? Throw money at the boomer to unlock the doggo cam. Wow, I can't believe there's 101 people watching. Hi, y'all! See, the annoying thing is, Carlos, I read that, and I read it both ways in my head. Is it castle or castle? Castle. Like your pants. I wear pants in the winter. No, it's pants, but I don't know. I don't know why. Castle is castle. Pants is pants. You wear your pants to the dance at the castle. Really easy. Why would they care about your accent in an early age? It's just not right. I'm sorry, late was watching Gelson. It's all good. White Castle. Lynn, good. They don't care and won't care until they are personally liable. You're aware of qualified immunity here, right? Yes, Daily Quick Bites. And are you aware that I rail quite heavily against qualified immunity? It was really funny watching that short that I put together about qualified immunity go. Because it was very clear at the start that YouTube very much wanted that one to tank. I was watching the analytics because I can see what my usual analytics are as to how many views I get, how many people swipe, and whatever. That short had almost 160% average view duration. So not only were people watching it, they were watching it again. But no, they tanked it and decided that it'd be okay to make sure that no one actually watched it. And then what happened? 11,000 views. Because people kept watching it. I thought that was amazing. Pants of Prison? Yes. New sub here came over from Vices. Oh, there you go. Cheers, Josh. Hopefully I don't run you off. But, let's face it. I generally don't keep my mouth shut. I will say things. I will... Watching Geelong defeat Brisbane. Oh, that's what you meant. Okay. Wait, Geelong took out Brisbane? Huh. Probably should go wake the wife up. But, anyway. Where is... No, got that. Oh, for anyone that doesn't know, the hotel from The Shining, the one that they use the exterior from for the Kubrick movie, it caught on fire. So, I don't know whether or not they're going to try and repair it or rebuild it or whatever else, but... Maryland high school student arrested after authorities discover a 129-page document detailing a school shooting plan. I regret even reading that. Fuck. Maryland high school student was arrested and charged on a threat of mass violence on Wednesday after police say they discovered evidence revealing the teen had a plan to commit a mass school unaliving. Authorities discovered a 129-page document they say was written by the 18-year-old Alex Yee. The Montgomery County Department of Police said, of course, it's always Montgomery County. He looks happy. Authorities learned of the writings following an exchange Yee had via Instagram messaging with an unidentified person who felt that a school shooting was imminent, according to the teenager's arrest warrant. I feel like that's a good way of just saying, hey, there was a, this kid was talking to an undercover cop online, but we don't want to admit that. I smile in all of my mug shots. They tell me not to. What are they going to do? Arrest me? The unidentified person knew Yee from an inpatient treatment at a local psychiatric facility, the warrant says. Yee referred to the writings as his memoir, which began with a disclaimer that is a work of fiction, the arrest warrant says. In the document, he writes about committing a mass school unaliving and strategizes how to carry out the act. He also contemplates targeting an elementary school and says that he wants to be famous, police said in the news release. A search warrant obtained by investigators led to internet searches, drawings, and documents related to the threats of mass violence. He looks like a white supremacist to me, says Michael Burke. The police department said it was notified by the FBI. Called it. about Yee's alleged writings, which prompted a joint investigation by the two agencies. Yee's being held at the Montgomery County Central Processing Unit, where he's being held without bond until his scheduled June 3 trial. Mass violence is a misdemeanor carrying a maximum penalty of 10 years in prison, Montgomery County State's Attorney John McCarthy said during a Friday news conference. CNN reached out to the attorney for Yee. The student has not physically attended classes since the fall of 2022. Holy crap, how long is this article? Oh, okay. And has been enrolled in an online program. Yee was hospitalized in December 22 for threatening to shoot up a school, homicidal and suicidal ideations, according to the arrest warrant. The student was then hospitalized for 5 months in 2023 at Johns Hopkins Pediatric Unit for homicidal ideations. Someone in class trashed his waifu collection. Am I insane for sitting here and going, well, hang on. These names keep coming up one after the other. Am I nuts for that? Every fucking time the FBI is involved. I'm more concerned that Johns Hopkins is involved. I'll be perfectly honest. Maryland, which I assume is in New York. Johns Hopkins, and they let him out. Yeah. Most recently, on March 15, FBI agents interviewed a school counselor who worked with the student from late 22 to early 23 and said Yee would express violent thoughts such as shooting up a school, wanting to hurt other people, and would smile while saying it, according to the arrest warrant. The student did say that he wanted to shoot up Wooten High School and his elementary school, but never stated the name of the elementary school. The counselor knows the school to be Lakewood Elementary. If he never said it, how do you know it? Oh, though, to be fair, he said his elementary school. I'm tired. That should have just, like... Maryland is in Maryland, it's a state. Not far from the state of New York, though. Oh, thank you. Appreciate the assistance. You mean John Drop Kids? In response, the school district has increased security as a precaution, specifically at Wooten High School, because of a valid concern of a school shooting, the arrest warrant noted, adding that they hope it would serve as a visual deterrent. He's in jail until June, and they're... Okay. I mean, I suppose a little bit of extra security and safety in the school district isn't gonna hurt. I think it's unfounded. Like, it's amazing how they do things when they don't need to, but won't do things when they do need to. Like, it makes no sense to me whatsoever. Charges are extremely serious, involving allegations of threats to harm to others, the school system said in a statement. We value and appreciate the close collaboration between MCPS and the MCPD in this matter, which is an example of our shared commitment to identify and address potential threats with due process before they materialize. Support staff and resources are available for both students and staff who may need to talk through the process. Most of these people at the school wouldn't have even fucking known. I guarantee at least one student or one staff member at that school woke up this morning and read this news article, and it's the first they fucking heard about it. Wanting to and doing are two different things? Yeah. I wonder if the FBI stoked his interest in all of this while they were catfishing mass shooters, or while instigating it. Damn good question, Ichiro. Ensuring that the safety and security of our students is... What? Ensuring the safety and security of our students is not just a priority, it's a daily commitment. Okay, well, I just...
FBI, open up!
Daily quick bites. My uncle was 30 years CIA, hardcore liberal, classical liberal. When Obama started destroying the CIA, he threw a fit. Never heard of him curse in my life until... Huh. There you go. CNN's Lauren Koenig contributed to the report. I don't really give a shit about that. So, where is... No, that's the thing about the GPs. I work for YouTube. This has all been a sting, and you're totally fucked. I tell you what, Still Life, if you actually work for YouTube, bring it. What's the worst that'll happen? You'll shut down my channel and I'll move to Rumble officially. Buy fronts, I want eggs. Well, you can have eggs if you want, mate. No, see, and the rest of the stuff that I had to cover was morbid. So I think I've been going for 2 hours. I'll probably call it a day. Whoops, wrong one. So, hopefully everyone's going to have a reasonable Saturday. I myself am going to be taking the family out tomorrow. So, depending on whether or not I'm up early enough, I will either do an extra early show, as in like an hour, maybe 2 earlier than normal, or there won't be another show until Titty Ball tomorrow night. My time. So, incoming picture of eggs. Lovely. But guys, hopefully you're going to have a good day. If not, go out and try and do one small thing and try and make the world a little bit of a better place. But as always, please remember, you are not a piece of shit. You have value and you do contribute to society, especially just for being here, listening to my ramblings, helping my viewership go up, and maybe, just maybe, if you've enjoyed yourselves, hitting the like button and double checking whether or not you're subscribed. But as always, people, stay healthy, wealthy, and wise, and I will catch you on the flip side. Cheers, peeps.
Out. Fuck this shit, I'm out. No thanks. Don't mind me. I'ma just grab my stuff and leave. Excuse me, please. Fuck this shit, I'm out. Nope. Fuck this shit, I'm out. Alright then. I don't know what the fuck just happened, but I don't really care. I'ma get the fuck up out of here. Fuck this shit, I'm out.
Oh, that reminds me to turn that off. I just realized that next to nobody I can think of is live, so what I'm going to do is, you know what, I'm going to send you over to Pirate Software. Just because I can. Maybe he'll learn my name. You never know. Anyway. Peace out, peeps. Oh, that reminds me to turn that off. I just realized that next to nobody I can think of is live, so what I'm going to do is, you know what, I'm going to send you over to Pirate Software.